Welcome to the Explainer. Today, we're digging into a fascinating legal mystery from way back in 1927. It's all about a man named Miguel Mamuyac and a will that just, well, vanished.
So what does happen in a situation like that? This question is the very heart of our story today. It's a legal puzzle that asks a court to figure out, was this critical document just misplaced, or was it intentionally destroyed by the very person who wrote it? Our story really gets going when Miguel Mamuyac passes away on January 2, 1922. Now, normally, settling an estate is pretty straightforward. You find the will and follow the instructions. But in this case, that simple first step kicked off a legal battle that would last for years.
To really get what's going on, you have to look at the timeline. At first, a will from 1918 was brought to the court, but everything screeched to a halt when a bombshell was dropped. Turns out, Mamuyac had written a completely new will in 1919, which basically made that first one totally invalid.
Right, so the key takeaway here is that the simple existence of that 1919 will automatically cancel out the earlier one. Now, you'd think that would settle things, right?
Nope.
It just kicked off the next chapter of this whole drama because now all eyes were on that 1919 will.
Okay, so the 1919 will is the one that counts. Case closed? Not even close. You see, in 1925, a new petition is filed to get that 1919 will approved by the court. But there's a huge catch. The person filing, Francisco Gago, doesn't actually have the original document.
And here is the big twist in the story. The original will, which everyone agrees was last seen with Miguel Mamuyac himself, was gone, vanished. The only thing anyone could find was a carbon copy. So the court was stuck with a really tough question. Is a copy good enough to determine a man's final wishes?
And this brings us right to the main conflict. On one side, you have the petitioner arguing that the carbon copy is perfectly valid and shows what Mamuyac wanted. But on the other side, the opponents are saying, hold on a minute. They claimed that original is missing for a very good reason, because Miguel Mamuyac destroyed it himself.
Since there was no original will to look at, the whole case really came down to what witnesses had to say. Both sides brought people to the stand to try and piece together the story of what actually happened to that 1919 will.
The judge in the lower court, after listening to all the testimony, was pretty blunt in his findings. He concluded that the will stayed with Mamuyac and that Mamuyac personally revoked it before he died. But how did the judge come to that conclusion?
Well, the case really pivoted on one powerful piece of evidence, an eyewitness. The court heard from a man named Carlos Bejar, who swore under oath that he physically watched Miguel Mamuyac cancel the original will back in 1920.
And Bejar even explained the motive. He testified that Mamuyac told him why he was canceling it. He'd sold some property that was listed in the will, so the document was out of date, and he planned on writing a brand new one.
And you know, it wasn't just Bejar's word against everyone else. Other witnesses, like the guy who actually typed the will and even the testator's own sister, backed up the story. All their testimonies painted a very consistent picture. The will was with Mamuyac, and then it wasn't.
Okay, so this is the point where the court shifts gears a little bit. It moves from listening to witnesses to applying a really important legal principle to figure this all out. Because when you don't have direct proof, the law often steps in with some logical assumptions.
This brings us to the core legal idea the court used here. It's called the presumption of revocation. Basically, the law makes a common-sense guess. If a will was last seen with you, and then it can't be found after you die, the default assumption is that you're the one who got rid of it on purpose.
Now, for this legal presumption to kick in, the court has a checklist. It looks for 3 specific things, and what do you know? All of them fit this case perfectly. Mamuyac had the will, he could easily get to it, and it was nowhere to be found after he passed away.
Now, it's really important to get this. This presumption is strong, but it's not unbeatable. The petitioner could have won if he'd brought evidence to show the will was just accidentally lost, or maybe that someone else destroyed it. But the burden of proof was on him, and he just couldn't do it.
So, you've got this powerful witness testimony on one side, and this very strong legal doctrine on the other. With all that in mind, how did the Supreme Court finally rule on the fate of that carbon copy will?
The final decision was crystal clear. The Supreme Court completely agreed with the lower court. They ruled that the carbon copy couldn't be accepted because all the evidence pointed to the fact that the original had been intentionally canceled by Mamuyac himself way back in 1920.
So let's break down the court's ratio dissidenti. That's just a fancy term for its core reasoning.
The court simply connected the dots. You have a missing original that was last seen with the testator, you have direct testimony that he canceled it, put it all together, and that legal presumption of revocation was just undeniable. Case closed.
And so, Miguel Mamuyac's estate was settled not by a clear document, but by a legal detective story pieced together from clues and testimony. This case is such a powerful reminder that a will isn't just about writing things down. It's about making sure those wishes actually survive to be heard. It really leaves us with one final thought. What can you do to make sure your own story never ends with a question mark?